What happens to an irrevocable trust when the grantor dies? A trust is really nothing more than a contract, a legal agreement where one party, the trustee, agrees to hold legal title to assets and manage them for the benefit of somebody else, the beneficiaries. Some trusts are revocable, which means that the trustmaker, sometimes also called a grantor, creator, or settlor, can modify or revoke the trust at any time for any reason or no reason at all. Other trusts are irrevocable, meaning the grantor may not change or terminate the trust. The grantor usually serves as the initial trustee of any trust, and when the grantor dies, a successor trustee replaces the grantor as trustee to carry out the terms of that trust. If you have questions, schedule a free consultation on our website at rmolawyers.com. How do you dissolve an irrevocable trust after death? While in general, irrevocable trusts cannot be changed, they can be modified or dissolved after the grantor dies in certain situations. For example, under California Probate Code section 15403, if all the beneficiaries agree, they can petition the court to modify or terminate the trust. However, suppose the continuance of that trust is necessary to carry out a material purpose of that trust. In those cases, the court usually will not modify or terminate the trust unless there is a reason for modification or termination that outweighs that material purpose. Also, under Probate Code section 15409, a trustee or beneficiary can request that the court modify or terminate a trust if the current terms would defeat or substantially impair one of the trust's intended purpose due to unforeseen or unforeseeable circumstances. For example, if a beneficiary becomes disabled, converting the trust to a special needs trust may become necessary to achieve the trust's purpose of providing for the beneficiary. This would be a change in circumstances. How long can an irrevocable trust remain open after death? Under California's rule against perpetuities, an interest in an irrevocable trust must vest or terminate either within 21 years after the death of the last potential beneficiary who was alive when the trust was created, or within 90 years after the trust was created. If neither of these conditions is achieved, then the trust may be avoided ab initio, or from the start. This means that most trusts cannot remain open indefinitely after a grantor's death. However, many trusts call for the distribution of assets and termination of the trust immediately upon the grantor's death. Can a beneficiary or trustee contest a trust? Sure. A beneficiary or trustee can contest a trust if they can prove that the trust is not legally valid. Here are some of the most common reasons a trust can be invalidated. 1. Undue influence or duress. If the trust was created or modified through undue influence or duress, it can be invalidated through a trust contest. Undue influence occurs when the grantor is manipulated by a third party to create or modify a trust. The amount of influence that has to be exerted over the grantor has to be so extreme that the manipulation overwhelms the grantor's own free will. Duress is a specific kind of undue influence where the influencer uses direct threats or force to manipulate the grantor. Second, fraud or forgery. If a trust instrument is the product of fraud, a beneficiary or trustee can contest its validity. Fraud can occur if a third party tricks the grantor into signing the trust, such as by telling them that they're signing a different legal document. Another type of fraud that can invalidate a trust is when the document or the grantor's signature is forged. Third, lack of mental capacity. For a trust to be legally valid, the grantor must have the mental capacity, they must be of sound mind, when the trust was executed. Although the legal standard for sound mind is not demanding, a trust can be successfully contested if the grantor did not have the mental awareness or acuity to understand what they were doing. When should I contact a trust litigation attorney? Dissolving, modifying, or contesting an irrevocable trust can be challenging, so you should always contact a trust litigation attorney before proceeding. An experienced trust litigation lawyer can review your situation to determine if you have sufficient legal grounds to terminate or invalidate or contest the trust, and advise you on the best course of action, most likely the one that will help you achieve your goals. Although you're permitted to proceed without an attorney, partnering with a knowledgeable trust litigation lawyer is going to give you the best chance of success. Have questions? visit our website, schedule a free consultation. At RMO, we protect you and your family's legacy. Thanks for watching.